Welcome to Wordpath, the show about Oklahoma Indian languages and the people who are teaching and preserving them. Tonight's topic is copyright, specifically what it is, how you can use it in your language program to protect your materials, and whether you can copyright, in fact, your entire language. These are sort of the three sections of tonight's program. Please note, and this is the disclaimer, I am not an attorney, and everything that follows is just my impression after doing some reading and talking to people about copyright and thinking about it. So be sure to consult an actual copyright attorney if you're making actual copyright decisions. Now, let's begin with some definitions. What we're talking about here in copyright is one of the areas of what's called intellectual property. There's physical property, like your car and your house and so forth, but there are also intellectual property laws, and they fall under three headings: copyright, patents, and trademarks. Copyright reserves for the authors and creators of books, articles, movies, videos, photos, a number of other things, computer programs, broadcasts, choreography, songs, the right to determine who, if anyone, may copy their works and under what conditions, and who will get any monetary proceeds from the broadcast, replication, publication, etc. of these works. The basic idea is that if a work is the intellectual or creative product of your mind or your artistic ability, you should be able to claim that product as your own and to reap the economic benefits, if there are any, for a specific period of time. There's always a time limitation on it. Even private letters and conversations have been considered covered under copyright law, which applies whether a work has been published or distributed or not. What's actually protected is the form of intellectual or artistic expression, not the content or the ideas behind it. Then there are patents, which I just want to mention briefly because they're separate from copyright. Patents protect inventions and technology, discoveries and that sort of thing from unauthorized copying and exploitation. And trademarks protect product names and other product marketing words, slogans and that sort of thing from use by others, which could diminish the value of the trademark holder's product or service. Both the patents and trademarks are administered by the Commissioner of Patents and Trades in Washington, D.C., but copyright is administered through the Library of Congress. We'll talk about more specifically who does that later. There are also even some recently conceived but similar rights of having to do with intellectual property, like a right of publicity. There was a case involving Johnny Carson's famous opening line on his show, "Here's Johnny." There was a producer of toilets who wanted to use the same slogan and was enjoined from doing so because of the Johnny Carson show sued them. Now, this wasn't a work of art or literature, and it wasn't exactly a trademark or a patented item, so they sort of invented a new concept, which was rights of publicity for slogans like this that people have a right to as an identifying mark of their enterprise. Anyway, all of these intellectual property rights are based basically in a certain clause in the Constitution, which I will read you. It's in Article 1, Section 8, Clause 8. And it talks about Congress having the power to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, end quote. So all of these intellectual property rights can be just held by the owner, the original owner, author, and so forth, or they can be sold outright to another person or a corporation or organization, or they can be sold, that is licensed on a temporary basis. And of course, with the sale or the licensing, there's usually a fee involved, which is negotiated between parties. So how does this relate to language work? Your language program or an individual working on your language may create a book, such as a dictionary or a grammar book, or a videotape, or an audio tape, or a CD-ROM. All of these things, if they are the creation of an author or a couple of authors perhaps working together, are usually copyrighted by the author. And this prevents other people from simply claiming them as their own, making their own copies and selling them for their own profit and so forth. It gives you control over your own work. We often see the sort of no trespassing signs that relate to these various kinds of intellectual property rights on works that the authors or the owners consider to be their intellectual property. For instance, the registered trademark label, a patent number or the phrase patent applied for on things that are where patent is being claimed, and also a phrase like copyright 1999 by Joe Blow. These are signals to the public that these are going to be claimed as intellectual property. Let me give you just a few more definitions before we get more specific about how you deal with copyright. These are related things. One is I wanted to make clear that there's a difference between plagiarism and copyright infringement. Plagiarism is not actually a crime, doesn't break a law. It's more an infringement of academic policies or publishing ethics and that sort of thing. Plagiarism, for instance, when they're students, are sometimes charged with plagiarism because, say, they're writing a term paper, they go to the encyclopedia or some other work, find something that's useful that's said about the topic they want to write about, and they just take it out wholesale, word for word, plunk it into their paper, put their name at the top of the paper. In doing this, they are claiming that these words are their own when in fact they're the product of someone else's work, and this is unethical, and if you have a good professor, they will flunk you out for doing this. But it's not actually breaking a law per se. The law related to copyright is called copyright infringement. And that is the unauthorized, that is unlicensed, use of copyrighted material without authorization from or license of the copyright holder. So this is what you want to protect yourself against when you copyright your materials. A couple of other definitions. One is royalties, and it's important to keep clear in your mind that royalties and copyright are not the same thing, although they're closely related. Royalties are the fees paid to the copyright holder or their designee for permission to use a copyrighted work. Usually it's something that happens each time a copy of a work is sold. For instance, if I author a book, I might hand over copyright to the publisher, and in exchange for that, the publisher says, yes, but we'll pay you this royalty every time a book is sold. You'll get $3 or something like that. So I'm getting some money. The overall copyright is held by the publisher, but I am getting some income. And this is done by a negotiated arrangement between the copyright holder and whoever they might want to make this arrangement with. So sometimes you might want to demand of someone that they let your language program, for instance, have copyright to their work. Let's say it's a linguist that's working with your tribal language program. There are several ways you could go. You could have the program hold copyright. And an area of the law that sort of comes into play here is that normally if someone is authoring a work for hire, let's say you hire someone to make a technical manual for your computer program, or you hire someone to write a dictionary of your language, or whatever. If they are working for you and are they're working as your agent or employee or consultant for a fee, then the normal assumption is that the copyright belongs to the company or the organization, not to the actual author. But when someone is working independently, or maybe you're paying them, then the normal assumption is that if they author something, then copyright will belong to them, unless they choose to sell it or assign it to someone else. So you can ask people to assign copyright to your language committee if you feel that you need to have control over the ultimate outcome of the work. And of course, all these sort of arrangements need to be made in advance. It prevents a lot of strife and conceivably legal difficulties and so forth. So you should, whenever you're working with someone on language materials, copyright arrangements and agreements should be discussed right up front and very openly. It's the best way to go. But another thing is that instead of handing over copyright, an author might retain the copyright for whatever purposes they may have down the road, but assign the royalties, that is, any income from publication of the work, to, say, your language committee or your tribe or the speakers who consulted on the work or whatever. So there are various kinds of arrangements you can set up. Royalties are not the same as copyright ownership. And one final definition is fair use. There is in general, you're not allowed to use copyrighted material without the permission of the owner of the copyright, and that often involves paying them some kind of fee. But there is an exception. There is free use of copyrighted material allowed by the law for purposes of, say, news reporting, to quote a brief excerpt from something. So-and-so gave a speech wherein they said, among other things, blah, blah, blah. Just because they wrote the speech and may want to hold copyright to it doesn't mean you can't quote a few phrases. Or for criticism, say, when you're doing a book review, you can quote a reasonable amount from the book as you discuss whether it's a good or bad book, and also for use in teaching. As you can imagine, this is kind of a gray area of the law. How much use is fair use? How much is copyright infringement? It's often these things go to court. But in general, the citing of brief excerpts for this sort of purpose is allowed by the law. Now, the whole area of copyright law can be very subtle and often involves tension between two concepts. The concept of protecting the creator's rights to their own product, on the one hand, and protecting the public's right to free speech, which is also guaranteed by the Constitution, on the other. So people can sort of say whatever they want, write whatever they want, but they can't write and sell as their own something that you have copyrighted as your own. And this is all carefully defined within copyright law, which I don't know a lot about, but I'm trying to outline some of the gist of it as I understand it to date. Now let's go on to the second part, which is suppose you have something you want to copyright. How do you do it? Let's say you are a linguist or a speaker of an Indian language or a tribal committee or someone that has recently produced a product related to Indian language. It might be a grammar book, a videotape, CD-ROM dictionary, an audio tape of conversational phrases. Any number of things are works which have been created by someone that might relate to language. You've put a lot of work into it, and you want to be able to control its duplication and distribution, which is part of what copyright ownership means. You decide if and when it's going to be published, how many copies will be made, how it will be sold, etc., etc. You have all those rights unless and until you sell them or give them away. You may also want to reap the profits from any sales of the product, either for your own personal benefit as an author or as a fundraiser for your language committee or whatever. So regardless of whether it's the money or just control of the product that you're after, you'll want to claim copyright to it. So what is the procedure? Briefly, the procedure is pretty simple. You need to place a copyright notice on the work. This is when you see that phrase usually on the cover of a book or the title page or sometimes the back of the title page. It needs to be placed in some prominent place, and it'll say copyright, the word copyright, or that C with a circle around its symbol. Then it'll say the date of publication and the owner's name. That's usually put all on one line and sort of highlighted out apart from everything else. So it's very clear that this is supposed to be copyrighted, because part of the law has to do with, does the person who supposedly infringed your copyright, did they have fair notice that in fact you were claiming copyright, or could there have been some misunderstanding? So you want this notice to be very clear. Actually, it's legally optional. You have copyright to your work, as long as you can prove it's your work, whether you put that notice on or not. But if it comes to a lawsuit, you really, it's good to have that notice on there and to have registered it. This is the second part of the procedure, registering your copyright with the U.S. Copyright Office at the Library of Congress. The way you do this is the office that's in charge of accepting applications for copyright and then issuing certificates of registration, which they send you when they accept your application. So what you do is you send them a copy of the work, a complete copy of the work. Send 2 copies if it's already been published, and one of those copies goes into the Library of Congress as a book in any library that can be circulated and seen by the public. The other one is just filed for registration purposes. You also fill out a form, and there are various forms depending on the type of work you want to copyright. The form SR is for sound recordings, TX is for non-dramatic literary works, etc. And you pay a fee. I wasn't able to find out today the current fee. I think when I last looked into this 10 years ago or so ago, it was about $25. So it's money, but not a lot of money. It's probably gone up some today. The form that you fill out asks for the name of the author and the name of the copyright claimant. As we discussed before, these might be 2 different people. One might be an individual and another a committee or a company. There are various arrangements possible. And if it's a work for hire, normally the owner is... the person that did the hiring is considered the author. The duration of copyright, this has evolved through the last couple of centuries in U.S. copyright law, but currently when you file for copyright, it will last for the life of the author plus 70 years. There's a sort of copyright clearinghouse that's available through the U.S. Copyright Office. That is, you can call them up and ask whether something is copyrighted or not if it's not clear from a copyright notice on the item itself. There's a fee, there's an hourly search fee they charge for doing this. But if you register your copyright, then if someone checks to see if your material is copyrighted or not, they'll immediately find out that it is because it's registered. So it's helpful to do that in that sense. So if you want to use some material that is copyrighted, say there's some old dictionary of your language that's been published and you'd like to use its contents in your modern dictionary and synthesize maybe a number of different sources and copyright them, you need to check out who holds the copyright and submit a written request for permission to use copyrighted material, and you need to confer with attorneys or with the Copyright Office about exactly how to do that. If you feel that someone has infringed your copyright, again, you need to get to an attorney. Notify the person, perhaps a lawsuit will be involved or some kind of injunction. Again, consult your attorney. But that's basically how it works. If you want to claim copyright, it's best to write that right at the front of your book or whatever it might be, or on the label of your tape, and then to register it with the U.S. Copyright Office, as I've just outlined. I'll give you addresses and phone numbers on how to do this at the end. There's a third topic I wanted to talk about, though, and this is something that, again, I didn't have time to get all the specifics and it's an ongoing issue. It's something you might have heard about yourselves if you're working in a language program. The issue is the idea of the possibility that you could actually copyright your language. Tribes have a history of, in many cases, of feeling sort of ripped off by outside researchers or professionals of whatever kind who come in and investigate the language, go off and publish recordings or books or whatever related to the language, claim copyright for themselves. The tribe receives no benefit, monetary or otherwise, and the people in the tribe end up feeling kind of ripped off, and as if their language has been exploited and they've been ripped off. So one of the ways that people have proposed countering this possibility is to just claim copyright to anything that's published in or about their language. And there are some tribes, again, I can't tell you exactly which ones, but there are some tribes that recently have claimed this kind of copyright notion. I think that that's not really something that's possible to do. Again, consult with an attorney if your tribe is considering doing this. But I'll detail in a minute, well, I think it's not possible. There's some interesting history here in a book I was reading called Copyright's Highway by Paul Goldstein. It's about kind of the philosophy behind the laws related to copyright. And it mentions this sort of related concept. It says, some time ago, African nations led a movement to obtain intellectual property protection for indigenous folklore, often hundreds of years old, against appropriation by writers and publishers in industrialized countries. So it's kind of a similar situation. When an American copyright expert challenged an Egyptian folklore advocate, saying, surely folklore is in the public domain, that is not copyrightable, the Egyptian replied icily, public domain is a very Western concept. Interesting case and an interesting background for the idea of copyrighting entire languages today, which are also rather ancient. And I guess this is a Western concept, but we're living in a country that's run pretty much by laws couched in Western concepts, so I think it's what we have to live with. One of the things about this idea of copyrighting your language, I think it raises, even more than most copyright issues, it raises this tension between the creator's rights or the claimant's rights versus freedom of speech issues. Since it would conceivably, it would, as I've heard these proposals have been stated, it would cover anything anyone might say or write in the language, that is, works not yet created. How can you copyright something that hasn't yet been created? It's kind of a strange concept, I think. I've charted some of the differences between what I think are copyrightable works versus languages, Indian languages or any other, I suppose. First of all, let's recap that the work is supposed to be, in order to be copyrightable, a work in general needs to be an original creation. It has to have identifiable, specific author or authors, and it has to be in a concrete medium of expression. So if you have an idea about something, you can't just copyright your idea. You have to first write it down, tape it, or something. So how does this relate to language? Well, a language, now historical linguists have tried for a long time to trace languages back, reconstruct, and sort of figure out what their previous history was. And with some people originally had the idea that perhaps you could go all the way back to somehow discover the creation of human language or of a human language, but no one's ever been able to do that. Languages are so ancient, and there is just in principle no way to go back and see who created them and when. So they are undoubtedly they were all the creation of some large community, probably over a period of generations. So you can't identify the author, you can't identify the publication date or the creation date exactly. Languages are by their very nature abstract. They are a set of principles that each speaker of the language holds in their own brain. And the entire grammar and description of how the system of a language works is never written down. It, in principle, can never be written down. Languages are infinite entities. So they're not definable, concrete things with specific authors, creation dates, and so forth. The language is always kind of an ongoing work. It evolves through time. So at what point are you copyrighting what? Already all these basic concepts are just very hard to apply to the idea of copyrighting a language itself. Anything that's copyrightable, this is sort of restating some of what I just said, but it needs to be the creative product of someone's mind versus a language which is the product of a whole community. Creation needs to be completed at a given point in time. We can't define that point in time for a language, so what date are you going to put on your copyright statement, and what are you going to write the copyright statement on? This notion of Fair use, too, is sort of hard to define with relation to a language. How much of use of the language would be considered fair use? If you have a book of 300 pages and someone quotes a paragraph or two, that's always going to be considered reasonable. But how much of a language would be reasonable? You can't really define the whole of a language, since a language is an infinite thing, so what percentage of infinity is going to be considered fair use? Again, you'd have an awful hard time defining that. Also, the purpose of copyright is supposed to be to encourage artistic and intellectual expression. This is one of the purposes behind the original clause in the Constitution, actually, and the original thought behind our early laws related to copyright. But what is the purpose of a language? Well, really, it's a communication tool. It's not really technology. It almost seems more like something that you would patent than copyright to me, because it is an entire system of that in essence is a tool of how to accomplish some purpose. It's a utilitarian thing rather than a work of art or intellectual expression. And yet in language all of this is sort of bound up together. Very problematic. Now, part of copyright law is that works cannot even be translated into another language. Your copyrighted work cannot be translated into another language without your permission. Now, if you try to apply this to the idea of copyrighting a language, what does that mean? A language is a system that, in principle, can say anything. Anything a human being can think can be said in a language. So if you copyright the whole language, then you wouldn't allow people to translate anything that could be thought by a human being into any other language. It seems to me you would be copyrighting everything in the universe. Again, I just think it doesn't quite make sense as applied to an entire language. Now, of course, computer languages are copyrighted, or I think they are copyrighted rather than patented. But these are finite things. They have specific authors. They are created at a certain point in time. They can be written down. A copy can be registered with the Copyright Office and so forth. Very different from a human language. You can only give a sample of that to the Copyright Office. Not enough to really justify registering copyright. Of course, another important part of copyright is the monetary proceeds, and that they go to the copyright owner or someone else they may designate. So who is the owner of a language? If a tribe claims ownership of the copyright, do monetary proceeds go to the tribe, to the language committee, to the people who speak the language? Do non-speakers in the tribe get the same benefit as speakers? How would you work all of that out? Pretty hard to work out. I don't want to beat a dead horse. I think maybe we'll just leave it at that. I think, suffice it to say, it's a pretty iffy proposition. I don't think it would hold up in the courts at all to try to copyright a language. What you copyright is a work in a language, perhaps, or in some other medium like photography or choreography or whatever, but not the language itself. The language is the medium, not the work. I think that's the legal concept that would apply here. So let's see. And if you think of in terms of trying to protect your language from exploitation by, say, scholars, linguists or something, there are scholars who write about human behavior, about nature, and all sorts of things that they use as data. A linguist is, in a sense, a language scientist. They cite examples of language as data for scientific theories. I don't think you can anymore copyright the language itself than you could copyright or patent the wildlife that a biologist observes or the behavior that a psychologist observes and so forth. Let's see, I just want to end this section by saying I don't blame people for feeling their language is slipping from their control. This is often a justified feeling. I just don't think copyright is the way to go about it. Well, what is the way to go about protecting your language then? I think if you can't copyright your whole language, how do you protect it? Well, of course, any works related to your language, dictionaries, grammars, tapes, and so forth, do copyright those and make sure that they're not exploited by someone else for their profit. And if they are, go after them for copyright infringement. But I think the best thing you can do to protect your language is to save it as a living language. Learn it if you haven't already. Make sure that the children in your tribe learn it. Keep the thing going as a living organism, as we've talked about before. And that's the best way to protect your language. No one can take from you what you're fluent in. They might publish things about the language, but they cannot take the language from you. So I think language preservation is the relevant category here rather than actual copyright registration when it comes to your language. And of course, you can sort of do some indirect restrictions. You can restrict access to the language community. Speakers can refuse to meet with people that they think might have exploitation in mind. And you can take that kind of care and those kind of precautions. Remember, a language can never be stolen from you. If you don't have it, it's because you let it slip away by not learning it or not teaching it. Finally, I'd like to give some resources for research on copyright issues. There are two books that I studied to prepare this program. One is this one I mentioned, Copyright's Highway, by Paul Goldstein. I wish I got it at the Norman Public Library. Another, which is seems very practical and useful, is called The Law of Copyright by Margaret C. Jasper. Also got this at the Norman Library, by Oceana Publications Incorporated out of Dobbs Ferry, New York. And finally, let me give you references for the U.S. Copyright Office. I think we have this on the computer, and maybe we could put these up and I'll read you some phone numbers and web addresses and stuff. This is the U.S. Copyright Office at the Library of Congress. Now, there's a 24-hour forms hotline, area code 202-707-9100. And of course, you can also check local libraries. Some of them carry copies of the copyright registration forms that you would need. There's also a web address given in the Jasper book, as I've written it here, but I think there may be a typo. It said ttp:// that's probably http://lcweb.loc.gov/copyright/. And the mailing address, U.S. Copyright Office, Library of Congress, 101 Independence Avenue, Southeast, Washington, D.C., 20559-6000. And of course, your ultimate resource, contact a competent, experienced copyright attorney. Good luck with all your publications and benefiting from them and making sure that language work benefits Indian language speakers and students. See you next time on Wordpath.
Wa pene madaole keta na hene yo hene ana magwana keta wa pene madaole keta na hene yo hene ana magwana keta wa pene madaole keta na hene yo hene ana magwana keta wa pene madaole keta na hene yo hene ana magwana keta wa pene madaole keta na hene yo hene